Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics or are your politics starting to shape your faith. In other words, what do you do when God and government come face to face? I'd like to introduce you to our regularly scheduled panelists for today. First, we have Mr. Todd McFarlane, who's the Deputy General Counsel for the General Conference of the Seventh-day Adventist Church. We also have Mr. Tim Schultz, who's the president of First Amendment Partnership, an organization dedicated to protecting religious freedom for all Americans of all faiths. We also have Mr. Viola Weiss with us, who's the Director of Public Affairs and Religious Liberty for the Indiana Conference of the Seventh-day Adventists. And we also have Lawrence Brown, who's the Assistant Public Affairs and Religious Liberty Leader for the Northeastern Conference of the Seventh-day Adventist Church. Gentlemen, great to have you here with us. Looking forward to having a great conversation. First topic I'd like to talk about today, gentlemen, the Supreme Court. With all of the activity that's been going on and the power of government and the way it's set up, it seems that our three branches of government are supposed to be in a way where two of them are going to be primarily political. The power of the president is one of the branches. Obviously, we have the legislative branch, who also is responsible for putting the laws in place. But the Supreme Court was supposed to be that third group, almost the umpire or the group that you would make sure are making rulings that have nothing to do with the public or anything to do with what may be deemed to be political in any way. But it seems recently we've been seeing a lot of court decisions and actually even comments that have been coming from justices. And even we're seeing even leaking of opinions, and even to some degree, justices acting as though they actually want to be pitching cases as opposed to simply receiving cases. And after we saw what went down in Bush versus Gore, we have to wonder, are we looking at a Supreme Court that's focused a lot more on partisanship? Or are we looking at a Supreme Court that's now starting to get a little bit separate and more even political as we go forward? I got to ask you guys what you think your thoughts are on this. You know, Tim Schultz, can you bring me an idea of what do you think about our system? It's very different than the rest of the world. We've got people on there with a lifetime commitment, and we now look like we may be getting a little bit more political than we may have seen in the past. What are your thoughts on that?
The Supreme Court has just, for at least 50 years, been deciding big, highly contested questions of national policy. And I think the Supreme Court has been intensely political, or at least perceived as such. It's at least the Warren Court. And probably before that, the civil rights cases, which I think the court got right. But the fact is that in a democracy, you're going to have the Supreme Court deciding big, important questions that a lot of people oppose. That was true this summer with the Dobbs decision overturning Roe versus Wade. And I think that that's just inevitable in a system in which highly contested questions are going to inevitably come before the court, including religious liberty questions. And I don't think there's really necessarily a better way than the way we have. It's just an inevitability.
Well, Todd, you've seen courts all around the world, and many of the systems that are at the top level do not have justices that are in there for lifetime positions. Most of them have a retirement age. Most of them have a cutoff. It seems as though by us putting in individuals from a lifetime perspective, we're not just simply getting, some protection against partisanism. As a matter of fact, it seems like we become stuck with partisanism. Am I missing anything here?
Well, I think the system that we have, one where there is, what we call lifetime appointments or in, good behavior, I do think is sort of the best approach, right? So other countries, Supreme Courts have different roles, different sort of involvements. The challenge is, if we had created a system at the very beginning that had a set amount of years, then, it's not that those systems, lead to chaos or anarchy. It's just that we have the system we have, and there really wouldn't be any way to sort of go to more a limited term without changing the composition of the court. And that's, I think, what's really motivating this, right? There's people that don't like the court's decisions, and so therefore they're trying to use sort of what sounds like a neutral view. Oh, we'll just put limits in and we'll have mandatory retirement ages, et cetera. Is sort of a neutral view, but it's not that, right? It's an attempt to sort of change the composition. I can guarantee you, if there had been a proposal, that Justice Breyer had been forced to retire during the prior administration, they wouldn't have been in favor of that. And in fact, there was pressure on Justice Ginsburg to retire during the Obama era, which she didn't do because they were afraid of, what ended up happening. So this isn't really about some kind of neutral, better system. It's about trying to change the composition of the court because they don't like the current decisions.
Well, Lawrence, let me ask you this. When you take a look at what's going on, where now we have justices that are going out saying, we're looking forward to getting this case in so that we might be able to make some quote unquote modifications or adjustment. Doesn't that sound like we're looking at more of a proactive group as opposed to one that should be more neutral in body?
Well, this is what concerns me. You have people that, whether they intended to or not, they are giving the very real sense that they are somehow beholden to the folks that, quote unquote, put them there in the first place. And that's never what you want. The way that this court got themselves in trouble is the same way that they can get themselves out of trouble. They have to demonstrate to both sides that their intention is to rule according to the rule of law. And failure to do that will leave them looking like they are mere puppets in the process. I make the argument over and over again. Process matters. People got bent out of shape about the Dobbs ruling. And my issue has always been, regardless of what side of the issue you come down on, you need to be concerned about how you got there in the first place. And the way the court at times has seemed willing to operate leaves you wondering whether that impartiality, that willingness to look at the rule of law and govern solely from that standpoint is still in play. And here's the other thing, which Todd alluded to. We are in a time where somehow we've equated, I didn't get what I want, with something must be happening, the fix must be in. And that's a troubling place to be.
Right.
I grew up understanding you don't always get what you want. And when you don't get what you want, it can't be, oh, I was cheated or something that happened. No, sometimes they just don't see it your way.
Well, I got to tell you, Vilo, it sounds like process does matter. But what's interesting is we start to see legislation where people are talking, maybe we need more justices. Maybe we need to change the numbers. Maybe we need to do this. It sounds like at the end of the day, what we really need to be looking for is just ensuring, as Lawrence is saying, that they're just making decisions based on the rule of law. Listen, Dobbs came in and overturned Roe v. Wade, but there was also a court that overturned some things with Brown v. Board of Education. Wasn't that exactly what we need to be doing?
Well, there are issues that have to be resolved, and the court has to deal with some of those things. One of the challenges too that calls into question the court's legitimacy is when it's legislating from the bench, which is a job that is Congress's job. And so, we look at some of those landmark cases, such as Brown v. Board and others, the Civil Rights Act, or the Voting Rights Act, and some of those other things that have been undergirding our culture. And the court has made some changes in the Voting Rights Act. It has unfortunately become political, even in the process by which justices are appointed. It's become far more political, and I'm concerned for the future of our court.
Well, I got to tell you, it's a good point that you raised there regarding how justices are appointed. Tim Schultz, I got to ask you, if we ended up looking for a different process, one where, quote unquote, we had more of an independent commission that was making these selections, would that give us a little bit more what I would call strength or legitimacy as relates to when those courts' decisions are being made?
I think it might, because it would depoliticize the process. I just think that that's not going to happen. So I honestly think that the kinds of things that I think make the most sense are things like, having justices have a mandatory retirement age, things like that. That would make it, I think, also depoliticize the process more, because it wouldn't, people wouldn't just be appointed to, when they're in their late 40s or early 50s to serve another 30 or 40 years, in some cases well past when they may be even physically capable of doing the job. So I think that those kinds of reforms are more realistic than some kind of independent commission.
Well, Todd, what do you think about this, though? There are a number of justices that come in where people assume they're going to be conservative or they're going to be this. And after a few years, we start seeing decisions that they're not exactly what people think that they were going to be. I mean, does that in and of itself almost justify the process we've been going through to some degree?
Well, I think it does show that this, the thing that comes with lifetime appointment, right, is a lack of of political accountability. I mean, there's accountability in a general sense, but if the president who appointed you, doesn't like the appointment, there's nothing he or she can do about that. And so you have seen a trend right now, for better or worse. That trend has only gone in one direction, right? We've not seen a justice get on who is more liberal becoming more conservative. We have seen several who've gotten conservative have gotten supposedly sort of more liberal. So the process has only moved in one direction. And I do think that that's given, some people a sense that the court, that care needs to be taken in who gets appointed, right? Because they have seen situations where people who've been appointed by one particular administration have ended up voting sort of against where you would expect that a person with that affiliation to be voting.
Well, I think where we're looking at all of this, and maybe this is a thought process, maybe we need a process where you've got to have a large number of senators that's more than just a quote unquote majority as we sometimes see. But at the end of the day, what we're looking at is maybe it's impossible to take the politics out of politics. If you're being appointed by a politician, is there any real way that this is not going to be political? I mean, Tim, I see you shaking your head. What are your thoughts on that?
No, I think that's right. And look, I think that America is just a much more complex country than it was, 100 years ago, right? Government and operating here are very complex. And I think the political branches of government have increasingly kicked the responsibility for deciding things to the courts. They haven't been doing the work that you would hope Congress would do. It's become extremely dysfunctional. And when you have that kind of a dynamic, the court is going to step in and resolve a lot of these national questions because Congress isn't, or because administrative agencies are taking that upon themselves in the executive branch. And I think that it would be better if Congress would get its act together a little bit, and then the court wouldn't be deciding all of these questions all the time.
And, I'm sorry, go ahead, Todd.
Yeah, I was going to say, yeah. I mean, one of the cases of the statutes I work with is called the Civil Rights Act, and there was of 1964, and there was religion is one of the components there, and that's the part I work with. There was a Court of Appeals case that called into question in the early 1970s, sort of part of what Congress intended there. Didn't even go to the Supreme Court. And Congress passed, as part of what was known as 1972 amendments, a fix for that, dealing with what the definition of religion is. That's almost unheard of now. The idea that Congress would address an issue and fix an ambiguity before it even went to the Supreme Court, we just don't see Congress acting that way because we see just malaise at the congressional level. And so, where there's a vacuum, power fills it. And the Supreme Court, I mean, the one nice thing about a court system is you will get a decision. Unfortunately, with Congress, a lot of times you get nothing.
Well, I got to tell you, Lawrence, it sounds that we're getting to a point where the law is using the Supreme Court almost as instant replay now. Instead of trying to fix it on the field at the beginning of the process, they're waiting and doing kind of like armchair quarterbacking at the end. I mean, is that what we're really looking at here, that they're taking over the role of being the legislators because the legislators don't want to legislate anymore?
That does, in fact, seem to be the trend. And the problem with all of this is it grows out of the clear dysfunction that has gripped that branch of government. It is ridiculous that Democrats and Republicans have lost the ability or the political will to sit down and have a conversation, not playing to the larger audience, but doing what they were in fact sent to Washington to do in the first place. And that's where our real problem comes from.
Well, I got to tell you, I'm going to have to let that be the last word, but trying to get politicians not to play to the audience, I don't know. They're voting for performers more than they're voting for politicians nowadays. So we'll have to see exactly where this goes down the road. But thank you very much for that conversation. Let's go on to our next conversation. There's a case I'd like to talk about with you, gentlemen, and it's a case that's called Tassinari versus the Salvation Army et al. It's an interesting case that was based in Massachusetts, where you have the Salvation Army that's being accused of discrimination. But in reality, its arguments are simply that we have some religious beliefs that if we allow ourselves to go forward and to maintain certain insurances on behalf of certain uses of opioids by individuals, it will cause such an increase in our cost perspective that it may put us in a position that we may not be able to afford to do what we're doing. But in addition to that, we believe that it is, quote unquote, a violation of our religious beliefs. A lot of proponents will say, hey, we're just simply looking to see how we protect ourselves. But those who are on the other side will say it's being used more as a sword instead of being used as a shield. You know, Lawrence, what are your thoughts regarding this? I mean, we have this idea that we want to make sure that we're allowing organizations to be able to, quote unquote, or even individuals claim their religious exemptions. But do we find ourselves in a situation where it becomes so tricky that maybe even courts are going to have difficulty finding what the right line of attack should be?
Well, isn't it interesting that a religious entity is on its face seeming to make a religious argument, but they're appealing to the financial realities that they're dealing with. So my question is the issue that as a church you don't want to proceed, or is the issue that you're trying to save money on what insurance is going to cost? Because those are two very different things. And this leads me to a concern that I have, that often we want to cast things in terms of having a religious concern, but then as you scratch and dig below the surface, you realize that it's not so much conviction on a particular point that's driving the argument, but something else wholly unrelated to religion in the first place. And I got to tell you, this is an area that makes me very nervous, because historically, we've been able to depend on certain things growing out of a religious basis. And now with that water getting more and more murky, I'm concerned about where we go in the future, and more importantly, how this impacts our ability to take care of real religious concerns when all of these other things have been allowed to flow in.
Yeah, I think that misstates what the Salvation Army's position is. First of all, the idea that just because, it's been framed as non-discrimination, but first of all, the Salvation Army has a theological belief, I think this is beyond question, that they want to run clean facilities, right? They want to have facilities that are free of drugs, and they don't believe that an appropriate way to get off drugs is to take more drugs. Now, you can agree or disagree with that. But the other thing is, this isn't just a non-discrimination law. This would require them to provide a significant number of services that they don't provide, and it would make the financial model that they're doing ministry with completely unsustainable. You can put requirements on any ministry, on any religious organization that will just absolutely bankrupt them. And the fact that the religious organization objects to being bankrupted by an unfunded government mandate does not cut into or reduce the legitimacy of their religion or the sincerity of it. And I think that is the problem here. These are programs the Salvation Army runs with their funds. This is part of their longstanding ministry. They're good programs. And I think what's really motivating this is plaintiffs' attorneys who are just trying to create a fee off of this, right? Because they're not just trying to end the non-discrimination. No. They want to get damages so they can get a fee. And I don't think it cuts into the sincerity of the Salvation Army when they say, listen, we want to run clean, sober living facilities and not have the government imposing mandates that would completely change the character of the program they're running and completely make their programs unsustainable.
Tim Schultz, it looks like you agree with that thought. Is that true?
I absolutely do. Look, the Salvation Army does so much good work for tens of thousands of people, hundreds of thousands of people who don't share their faith. And for the government to come in, it's not like the Salvation Army is lining its pockets and has, golden toilet seats in their facilities. They know their business model. They know what it takes to take care of people who are suffering. And for the government to come in and tell them what their model, their care model ought to be is the height of arrogance. And I completely agree with Todd. I think it's pretty outrageous.
Well, Vilo, isn't it a little bit tricky when you're starting to make a religious argument, but somehow the financial component comes into play? Lawrence used the term murky. Does that make things a little murky from the other side when you look at an argument like this?
Well, what an organization believes is core and is central to what they believe, and I think they have the right to advocate, for that. The financial side, does create some questions, but yet on the other hand, can the government force them to go bankrupt because of what it's going to cost them? I know the church organization that I'm involved in, insurance controls a lot of what we can do.
Well, that makes a lot of sense. So it sounds like this substantial burden that's been created on them is really the argument that you really have to kind of flow through. Lawrence, when you think about the substantial burden, it sounds like what we're saying is if you're pressed into a position where it could cause you to quote unquote go out of business financially, then just because that's in conjunction with your religious beliefs, maybe that doesn't make it so murky.
So here's the thing, and admittedly, we're dealing with a particular case right now, and the point that I'm making is probably more applicable outside of it, because as we spoke about in a different segment, you began to see a lot of people all of a sudden, quote unquote, getting religion when they decided they didn't want to get vaccinated. Now, many of them had no religious underpinning at all. It was just driven by, I need something, boom, here it is, I'm gonna grab it. So in all fairness, the good work that the Salvation Army does, this case probably wasn't the best highlight for what I'm talking about. But this idea that we will use a religious argument, and again, not saying that's what the Salvation Army is doing, but generally speaking, you're beginning to see people willing to use religious arguments when in fact, those concerns are not growing out of any kind of a religious conviction about it. It's just, something that's there. I'll grab it and see what grows out of it.
But Todd, you have to agree, there's some issues where we're looking at organizations wanting to use religious arguments whenever things may get inconvenient, or maybe when even they get expensive. And because of that, that will cause some people to say, wait a moment, where do we, pump the brakes and see exactly what the difference is?
Well, listen, this trying to separate how a ministry uses its money from its religious mission and so forth, I think is just a false dichotomy. So, the government can put certain restrictions on and certain requirements that can cost money. So, for instance, if you're going to build a church, it does probably need to meet various fire codes and other things. And those are expensive, right? I mean, it's a lot cheaper to build a building that doesn't meet fire code than it is to build one that does. But the challenge here is when you're talking about something that does intersect in a core way to how mission is being done and how a program is being provided, increasing that cost just simply because the government thinks it needs to be done a different way, is I don't think, cuts into or their, sincerely held religious beliefs or calls into question those beliefs. We talking before, about the Supreme Court and, how the importance courts are. Remember, it's not like Congress passed a law with the intention of making this to require Salvation Army to do this, right? This was part of, the Rehab Act and the Americans with Disabilities Act. And a law was passed a very long time ago, and there's just been various court interpretations that now sort of land on this. And this is a perfect example of there was no democratic process here to determine to do this. There was a process to protect disabled people that now has been interpreted in such a way that it requires them to provide services that they aren't comfortable providing. So I do think, to kind of harken back to our last conversation, this is an example of where courts have sort of interpreted laws that were written very broadly in a way that now cause the conflict.
And Vilo, I think this is a good point that Todd is raising, that part of the role of the court, some people may say is being aggressive or being politicizing, but their role actually is to clarify points that maybe were not necessarily going to be, clear based on certain rules or regulations or even prior cases. So we could be looking at a little bit more of that and may see that more happening even in the future.
Yes, we certainly could, because somebody has to make a decision, particularly if you have administrative agencies that are imposing these requirements based on congressional acts, and it's creating a real burden. Somebody's got to provide a relief. The challenge, though, is that this religious basis of this conviction has to be, I think, very core, not something supernatural. Not supernatural, but I mean superficial.
No, I understand that. And Tim, I think that's a key point here. An organization being able to demonstrate that this is not something new. This isn't something that just pulled out of the sky recently. Seems like that should be a critical part of the analysis that takes place here. And that seems to be what the Salvation Army is pointing to.
Like I said, I think the Salvation Army is right in this case. And I think that it's not so much just about this case, though, right? It's about the question of is the government going to partner with faith-based agencies that serve the common good and generally defer to their judgments that they know pretty well because they're close to the situations, how to handle these things? And I think this isn't just about this case. I think it's about a whole lot of other cases that are going to come about that are very much like it.
And I do want to stress, though, that while that is an issue, remember, in this particular case, this is not a government-funded program. This is simply Salvation Army running the program with their own funds.
Right. And given the discussion that this topic is generating, not just in this room, but in other places, it also harkens back to why it is so important that there can be a level of trust in the room, that the people who are operating from a good faith basis and are literally trying to make decisions according to a process that all of us can appreciate. Because when people start to feel like the fix is in, then it's harder to deal with issues like this because everyone is looking at it from a skewed basis.
Well, I think the question about the fix being in is what we all have got to be concerned with. And when we're doing anything from a court perspective or even from a legislative perspective, it's so important that the people are comfortable in knowing that the fix is not in, but it's actually just the right decisions that are being made. Gentlemen, I just want to thank you a lot for that conversation. I think that's one we're going to be talking about for a long while. How do we separate what's going on between being, quote unquote, from a faith perspective, from a discrimination perspective? And I don't know if we'll ever get to the answers anytime today. Todd, tell me something I don't know.
The United States Supreme Court that we talked about earlier did not have its own building until 1935. Prior to that, it used space in the U.S. Senate, in particular, the U.S. Senate's old chambers.
Wow, didn't know that. Lawrence, tell me something I don't know.
Given the cast of caricatures that have walked across the stage in the last little bit, offering themselves for public service, I think we need to stop saying anyone could be president or anyone could run for office and start saying maybe anyone could, but maybe not everyone should.
Vilo, tell me something I don't know.
I didn't know that in 1884 that our government banned American Indian religious practice.
Wow, didn't know that either. Tim, wrap us up. Tell me something I don't know.
The largest religious group in the United States are people who describe their religion as none.
Wow, that's where we are today. Gentlemen, thanks so much for that conversation and looking forward to doing this again sometime soon. I want to thank you for being here with us today. Hope you enjoyed our conversation. Just remember, if it's about God and government, it's faith and politics. See you next time.